Good afternoon. Welcome to the Appellate Division, First Department. We have some 6 hours of argument time requested this afternoon, so please keep that in mind as I call the cases and ask only for the time that you'll absolutely need to make the most important points. Remember that we have the record, we have your briefs, and we're fully familiar with the facts of the cases. First case, Peoples versus Abdo Diallo. 5, 1, and 4. Thank you. Davis versus Mellifont Construction.
Respondent, Your Honor, 5 minutes.
You have no appellant. Do you wish to submit?
I'd like to argue if I can.
I'll give you 2 minutes. Unique B is a submission. Kamara versus LA Fitness.
For defendant, appellant, 6 and 1, Your Honor. For respondent, 5.
6, 1, and 5. Walber, 82nd Street versus Fisher. 5 and 1 and 2? 2. People versus Kenneth Martinez.
Appellant requests 4 and 1, please.
People request 4 minutes.
4, 1, and 4. 214 Knickerbocker versus Pan.
Appellant, 4 and 2, please. Respondent, 5.
4, 2, and 5. Thank you. Ledesma versus Rodriguez.
Appellant, 5 and 1, Your Honor.
There doesn't appear to be a respondent. Do you wish to submit?
No, I'd like to argue, Your Honor.
2 minutes and a submission. Carr versus New York City Division of Housing.
Appellant, 7 and 2, please.
7 and 2, 5 and 5. Thank you. People versus Dennis Jennings is submitted. Marion Scott Real Estate versus River Bay Corp.
Respondent, 8 minutes.
7, 2, and 8. Senall versus Lynch. I don't see a respondent.
I'd be happy to answer any questions, ask for 4 minutes.
The bench doesn't have any questions. If you want to argue, I'll give you 2 minutes. Murphy versus Kozlowska. Submitted. People versus John Arias.
Appellant, 6 and 1. Respondent, 6 minutes.
6, 1, and 6. Offenbach versus Olbaum.
Appellant, 4 and 2, please.
Again, no respondent. Do you wish to argue?
If there are questions the panel has,
No.
2 minutes.
Okay. Are you asking if there are questions the panel have? The panel doesn't appear to have any questions. Are you wanting to argue for 2 minutes? Okay, submission. Thank you. 88 Greenwich owner versus 21 Rector Street. Submitted. Adder versus Adder. Submitted. First case for argument is People versus Abdou Diallo.
Thank you, Your Honor. Whitney Elliott of the Legal Aid Society for the appellant Abdo Diallo. The court should reverse the denial of the motion to controvert the search warrant for at least 2 independent reasons. First,
So just to begin, I have to ask you, there was a waiver in this case.
there was a
right?
waiver in
So
this case.
why doesn't the waiver foreclose the review of the suppression issue?
So 3 points, Your Honor. First, this case is exactly like People versus Francisco, where the court told Mr. Diallo that as a result of his guilty plea, he lost the right to contest any search and seizure. And this court invalidated that waiver because the right to, you do not lose the right to appeal a suppression denial as a result of a guilty plea. And that, I think, alone is dispositive. Second, The court also described the waiver as an absolute bar to a direct appeal. So that would be an independent reason in addition to the Francisco-based reason. And third, we don't think the written waiver cured any of those defects. It did not inform Mr. Diallo of the right to counsel, and it also broadly described the effect of the waiver as a waiver of all of his appellate rights. So for those reasons, it doesn't bar any of the claims we're raising here. On the merits, Officer Lopez's unverified allegations about the informant's past work for the NYPD did not satisfy the reliability requirement for a finding of probable cause. And second, the warrant's no-knock provision issued in violation of Richard versus Wisconsin because it did not allege any facts distinguishing this case from any other drug investigation. With respect to reliability...
Just back on that point, was there a concern here that this was some sort of drug distribution center and that the drugs could be disposed of? Could that have been a basis for the no-knock warrant?
No, Your Honor. There was, in terms of a drug distribution center, no, it just described 2 controlled buys without specifying the amounts of drugs involved. There were no allegations about the amounts of drugs in the dwelling. But in terms of the disposability of drugs generally, that is, I think, a critical point because that's, in effect, what they relied on for the no-knock provision. But as we point out, basically all drugs are easily disposable. And the disposability of drugs generally can't be a fact that distinguishes any particular drug investigation from any other. And if a warrant issues on that basis, it could only have issued on a no-knock warrant issue on that basis. It could only have issued on the kind of blanket rule allowing no-knock entries in drug investigations that Richards expressly prohibits and found to violate the Fourth Amendment. And the only other distinguishing fact that was alleged or allegedly distinguished was that there were sinks and toilets in the apartment. Again, that fact doesn't distinguish this drug investigation from any other. All dwellings have sinks, just about all dwellings have sinks and toilets. There's nothing to distinguish this case from any other to justify the significant intrusion of a no-knock entry.
Could you actually take a step back and tell me, were these specific arguments, were they preserved when you made your general challenge to the search warrant?
So I guess we would say yes, and I would make 3 points about that. At the time of the omnibus motion, the defense did not have the warrant or the warrant affidavit, but there was a general motion to controvert. And they couldn't have more fully specified the bases for challenging it without the warrant or the warrant affidavit. So we think that adequately preserved it. And we think it's really just like People versus Esperanza, where the court found a suppression argument was adequately preserved precisely because at the time of the motion, the defense lacked the relevant information to more fully specify the bases for the challenge. But even if the court disagrees about that, the no-knock issue in particular should be reached in the interest of justice. It was so clearly deficient under Richards, alleging only that there was cocaine in the apartment and that there were sinks and toilets in the apartment. It's such a clear violation of a over 25-year-old Supreme Court precedent, Your Honor, that the court should reach it in the interest of justice. If there are no further questions, I'll reserve my time. Thank you.
Good afternoon, Your Honors, and may it please the court. Stacey Nadell for the people. The search warrant here was proper in all respects and at the outset is entitled to a presumption of validity because it was reviewed by the issuing judge with all the facts alleged before it and alleged here. At the outset, all of the defendant's claims regarding the search warrant were unpreserved. The defendant points out that the defense counsel below didn't have the search warrant at the time of the omnibus motion. However, in the people's response to the omnibus motion on page 2 in the footnote, the people had stated that they had provided a redacted copy of the search warrant and the affidavit to the defense. That motion was was dated on October 29th of 2015, the affirmation of service November 2nd of 2015, and the defendant pled guilty on December 14th. So there was ample time, over a month, for the defendant to raise an issue with the search warrant or the affidavit. However, on the merits, The defendant's claims are still unpersuasive. The CI who provided the facts to Detective Lopez was credible, reliable, and had a sound basis of knowledge. Most importantly,
What about the no-knock warrant? Because that seems to be primarily the claim that we should reach that in the interest of justice. What did Detective Lopez say that would justify the warrant?
so Detective Lopez worked directly with the confidential informant to conduct 2 controlled buys at
So that aspect goes to the reliability of the confidential informant, but your opposing counsel spoke about the absence of information in the no-knock warrant, indicating that it just said that there were drugs and toilets and sinks. In other words, that wasn't enough to show the exigency for why a no-knock warrant would have been necessary. So can you speak to that aspect?
Yes, Your Honor. So the fact that the confidential informant was inside the apartment on at least two separate occasions, the confidential informant was able to see the apartment layout and the sinks and the toilets and was able to say there are sinks and toilets here, that the drugs can be easily disposed of there. Further, the search warrant...
Well, did he say that the drugs were in the bathroom?
He did not, Your Honor.
So, in other words, if you're in an apartment, presumably the sinks and toilets work, and the drugs are in some other room. I could see if you're saying the drugs are stashed in the bathroom. I mean, I'm trying to find out what else is the reason for that.
Yes, Your Honor. So the search warrant was specifically looking for cocaine. Cocaine as a powdered substance is easily able to be dumped down a toilet or a sink with, if you compare it to syringes, to sheets of LSD, for example, that is not as easily disposable. But because the officers were looking for cocaine here, there were sinks and toilets, not to mention that Detective Lopez has experience with executing search warrants and seeing targets of those search warrants dispose of those drugs in that way. The fact that even though those factors are seemingly typical in felony drug investigations, because here it is cocaine easily disposed of down sinks and toilets, that is fact specific based on the exact type of drug and the sinks and toilets. And as to Richards, the police just must have reasonable suspicion that failing to knock and announce would inhibit the investigation by allowing the destruction of evidence, and that was the case here based on the confidential informant's ability to describe what this confidential informant saw in the apartment. And if there are no further questions, we ask that you affirm in all respects.
Thank you.
Thank you.
Thank you, Your Honor. I think 3 quick points in rebuttal. I just want to emphasize, I think the court has just heard from the other side, is that in their view, sinks and toilets, powdered drugs in an apartment, that's enough to get a no-knock warrant in their view. That is just flatly inconsistent with Richards and the
But
cases.
the fact that it was also an active drug location, or that the confidential informant just went there the week before and made 2 purchases, so it was known that drugs were actively being sold on a regular basis.
Well, still, that's anytime there's a warrant, there's going to be a basis for believing that drugs are in there. That's how you get the warrant in the first place.
So what would you say would be sufficient to justify fact-specific arguments as to why no knock is appropriate?
Well,
It
post-Richard...
didn't have in this case.
Sure. Post-Richards cases have talked about, for example, if the officers know that the drugs are being kept, for example, in the bathroom next to the toilet to allow for a quick disposability if the police enter or knock.
So there are myriad cases where drugs are disposed very quickly, and the drugs are in the living room or the drugs are in the bedroom. The people are inside, and once there's a knock, that's plenty of time to go where you know the drugs are being held to flush them down the toilet. Is there a requirement that the drugs be stashed in the bathroom?
No, but there has to be some kind of case-specific thing, that distinguishes it from another drug, from drug investigations generally. The presence of drug sales and people in the apartment, those are the kinds of things that were aired.
What about drugs that can be flushed easily, like powdered substances?
Well, I think like the post-Richards cases that we cited, for example, have required something more. Just the general disposability of drugs that allows for the kind of blanket rule that Richards expressly rejects. There has to be something more than that. So, thank you.
Thank you both. I noticed that our placement is off. Appellants are usually on this side. Respondents are on that side. So we're going to take a moment to change that. In the meantime, Davis versus Mellifont Construction.
Good afternoon, Your Honors. May it please the Court. My name is Robert O'Hare, and I represent the respondent in this case. As an initial matter, Your Honor, our position is that the arguments made by the appellants in this case were not properly preserved in the lower court. What happened in the lower court was that there was a motion to strike demand for punitive damages with respect to.
Me too, right?
That's right. It was a Me Too. It was a Me Too cross motion.
One of the only other issues, why don't you respond to that, is their argument that you can never have punitive damages in a respondeat superior kind of case. Why can you?
Well, we say here because there are facts which were set forth in the supporting papers in opposition to the motion that showed that there were a number of things that had transpired that would have been the responsibility of the employer. And those things were he was operating a 13,000-pound commercial vehicle on a residential street loaded with construction debris in the middle of the 13,000 pound.
Okay.
13,000 pound. It was essentially what looks like a garbage truck that's used for demolition work, and it was loaded with construction debris. They would have had control over the driver. They would have had control over the roadways that the driver took. As the record demonstrates, the vehicle is being operated on not on the truck routes that are designated by the city. The driver admitted to the police upon his arrest that he had been consuming alcohol during the lunch hour. Once again, failure to supervise their employees. There was also statements in the record with respect to the amount of rest that the driver had had the evening before. He stated in writing that he had only slept 4 hours before. That violates the DOT regulations. It also violates the Federal Motor Carrier Safety Act, which is incorporated by the Department of Transportation.
Thank you.
And if I may, just one last thing, Your Honor, with respect to
I'll give you
a
30
case,
seconds for that.
I took the liberty of, when I saw who the panel was, of pulling one of a case that you were sitting on, Judge Renwick and Justice Kern, and that's the Borst versus Lower Manhattan Development Corporation, and that's at 162 AD 3rd 581. And we would submit, Your Honors, that that is on all fours. The only difference in the procedural posture of that case, that was on summary judgment. Here we are at the pleading stage. We should be given every benefit of the doubt. And with that,
Thank you.
Thank you.
Kamara versus LA Fitness.
William O'Connell, Goldberg, Segala for Defendant Appellant, LA Fitness International, LLC. Good afternoon, Your Honors.
Counsel, this is in a gym, essentially, where the individuals are invited to come in. Obviously, they have memberships. They come in and they use this machine, and this machine is one where there's a removable handlebar. Why isn't it res judicata? Why doesn't res judicata apply here, where, I mean, you have responsibility to take care of these machines, and it's not something that can be removed readily by the individual. It's something that would require special equipment. So why, even though obviously people have access to it, why wouldn't res judicata apply here?
Your Honor, I just think some of the factual premise of that question is not accurate. I think the testimony that I cited in my brief is pretty clear that this is a handle that is removable, replaceable, and there are multiple different type of handles and link mechanisms which attach to the machine.
There are
Sure.
there are handles that are removable.
Yeah.
That's right. But they're not removable by the part that came apart. They're removable by the link. Isn't that correct?
Well, the handle is removable and the link is removable.
But the handlebar for a patron to come in and use the machine and one who wants to change the handlebar, they simply have to remove the link. Isn't that correct?
I don't think that's correct, and I don't think it's clear in the record. I think that a
So if you
user,
were instructing, if somebody from the gym were instructing a patron, they would explain that they should remove those washers and other devices to replace the handlebar. They would not instruct them to remove the removable link to replace the handlebar. Is that what you're saying?
no, I'm not. What I'm saying is that handles are removable and the quick links are removable, and therefore, regardless of any instructions given by my client, that they're handled and they're handled continuously, and that can cause a loose nuts and bolts.
So is your point that you don't have exclusive control?
That was, and I was trying to focus
Let
on
me
Justice
ask you
Reimer's
this,
question.
can you remove that link without a wrench? That bolt? Can you remove it without a wrench?
I think you can. I mean, I think plaintiff made an effort to show that there was a thread there and that you could easily do that.
So you're saying that one of the gym patrons could have mistakenly thought the way to do this was to roll off that's possible?
Well, what I'm
It's
saying,
unclear to me from the record whether you would need a wrench or not to remove that.
well, again, a lot of that comes from the Pavon case, which this court decided. I respectfully think that the judge in this case, Justice Douglas, who's a terrific judge, was too much swayed by the Pavon case, and the cases aren't similar. In this case, it was actual parts and equipment that was handled by users.
So that's, I guess, my question to
Yeah.
you. Is there evidence in the record that anyone moves that piece?
Well, there's evidence in the record to connect the different handles to the link mechanism. The user is required to open up a gap.
Yeah.
That's not that. That's not that piece of equipment.
Right.
That was my question. There's a piece of equipment that clearly has a device on it that is
Right.
to be moved by hand, which is not removed in the photos within the record. It is in place. What is removed is the mechanism beneath it. So the question is, why would anybody who wants to remove or replace the handle, which they are invited to do with that machine, why would they remove the washers and other materials below? And I'll ask you this, if you could also answer it. Why would they be able to do it by hand? That is something, as my colleague has instructed, that requires a wrench or something else. Why would it even be something that could be removed by hand? I understand that someone who testified on defendant's behalf indicated, someone from the gym said that they get them, there's maintenance of those machines.
Yeah.
But they don't check the washers. So they wouldn't have checked this in any case.
That's not the testimony. The testimony is that when they were doing checking, they inspected. They did not inspect every bolt and washer in the entire store because there were 270
They don't
machines.
inspect every bolt and washer in the entire store. Is there any evidence that they inspected those bolts and washers?
No, there isn't.
Okay.
But, okay, Your Honor, but we're also talking about a plaintiff's motion for summary judgment here. Justice Higgett, do you have a question?
I'm sorry, sir, if you wanted to, if you had
No,
any more.
my point was just, I think we missed the first part, which is on plaintiff's motion for summary judgment. Obviously, the evidence has to all be viewed in my client's favor. And in this case, where they're seeking summary judgment under res ipsa, it has to be such convincing proof and the defendant's so weak that the inference of defendant's negligence
Counsel,
is
what is your
inescapable.
point with respect to why you say that exclusive control has not been shown?
Well, my point is that because there are these two pieces of equipment, that the handle and a snap link and a quick link, there are two types of links. So to the extent that those are being exchanged and replaced and used by different users, then that could cause a loosening of things, and that's by other people, other persons who are going to the gym. That's not my client's fault. I understand we have a maintenance requirement, and we have evidence in the record that we performed that. Yes, Your Honor.
Were each of the various components of this instrumentality accessible to the general gym-using public?
The two that could have any relationship to loose nuts and bolts, yes, they did. They are removable and they can be replaced. So plaintiff says I didn't replace it. And plaintiff says that was a permanent handle. But that's just plaintiff's testimony on his motion for res ipsa for summary judgment. We don't have to believe that. We don't have to agree with that. And there is evidence in the record that I respectfully suggest Justice Douglas didn't really ascertain, that there also was evidence that it was removable, both pieces were, and that doing all that changing can loosen bolts.
So I just
without the
want to make
negligence
sure
of my
that I'm...
client. I'm sorry.
No, I talked over you. It's okay. I just want to make sure that I'm clear on this. If someone at the gym is instructing someone on how to remove the handle, what would the instruction be for how to remove the handle?
The instruction
To change, because they're interchangeable. What would the instruction be?
I don't, there's no evidence of instructions in this case, but if the instruction presumably would be to take the link mechanism and to handle it with your hands, open it up, and take the removable handle off. That's touching it. That's continuous touching, like dermatosian in the city bus case, and you have to use your hands to change the equipment. I mean, I'm sorry if I didn't make it clear, but because these two pieces, the handle and the snap link, can be removed, that there certainly is some evidence in the record that the handling of these pieces of equipment could cause loosening of nuts, which should be tightened at some point. Yes, I agree, but that could have led to this accident. That's my point. Sorry.
Good afternoon. May it please the court. Aaron Fein for the respondent. Regarding the issue of exclusive control, yes, although the grip can physically and literally be removed, the issue is the public invited to remove the grip?
I don't know that that's the public. I don't know that that's really the question, whether the public is invited to touch it. The question is whether the public can touch it. Someone comes in and they are grabbing at that mechanism. It's not within the exclusive control, is it?
Well, I respectfully disagree, because the issue also is there's kind of two parts to the analysis. Is the public, or members of the public, invited to access it? And then part two.
Saying invited, but is that really the legal standard? Isn't the whole idea of rep ipsa that no one else has the ability to access it, and you're the only one who can access it? So because you're the only one who can access it, we're going to say you're responsible, you know, on res ipsa. But if the public can access it, whether or not they're invited to, doesn't that undercut the whole basis of why we have a res ipsa analysis?
No, Your Honor, because the analysis is whether or not what scenario was more likely than not to happen.
But this is a summary judgment case. That might be true in a trial, and the jury can decide whether or not to apply it. But you're saying that as a matter of law, you're entitled to summary judgment applying it. So if that's going to be the case, doesn't it have to be clear as, you know, as a bell that no one else can access this equipment?
Well, I would point the court to the case relied upon by respondent in our brief. It's a New York Supreme Court case, Fickelman versus Equinox, where summary judgment was granted for very, very similar circumstance. But I would say no. The analysis is still the same.
You said that was a Supreme Court case, but there are Court of Appeals cases here with regard to res ipsa.
Right, and
And I'm sorry, what's the name of the case that you're relying on?
it's Fickelman
Mr.
versus.
Fickelman? Well, just remind me in Fickelman, because I did read it this morning again. The part that snapped was the cable close to the machines. Now, was there testimony that that cable was being handled by gym patrons, as there's testimony here that the cable, that this handlebar is being handled?
Well, the issue in Fickelman, as this case here, was that a bolt came loose. Which
Sir, we're talking about exclusive control. Exclusive control. The Supreme Court in Fickelman said exclusive control because that's a part of the machine where the cable snapped or the bolt came loose was a part where gym patrons did not handle, unlike this case, correct?
No, the gym patrons did not handle the bolt on this grip.
But how could how could one remove, if they wanted to remove that handlebar? We're not talking about whether they took something and changed it. Now I'm asking a different question. To remove it, wouldn't they in some way have to grab on to hold it while they remove the link and took it off? So would that then be exclusive control as some of these Court of Appeals cases speak of in terms of exclusive control, that the person actually has access to it, can touch it and handle it.
I would say no. It would be exclusive control if the patron had a reason to do so. And in this situation, there's absolutely no reason that a patron would as you explained, grab the handle, bring a wrench, or find a wrench.
No, that's not what I'm saying. I'm saying in order to take it off, which is to unscrew that piece for the link that comes off, the way it should come off, the link there, you take that off. In order to do that, you have to hold something with one hand as you take that other part off. I mean, one's hand can come into contact with that piece that actually fell apart. Is that not true?
I presume.
And then would that be exclusive control or not?
In that very specific scenario,
I don't know how specific it is. It's there, they're using the handle all the time.
well, I would say it's specific because I would submit that that scenario is almost an impossibility in this situation.
Wait. Are you saying that someone couldn't just be mistaken and not understand, oh, instead of using this link, I have to unscrew the bolt, which is exactly what happened here? You don't think that that's a possibility? Actually, let me withdraw that. How are you proving exclusive control as a matter of law? Let me ask you that. How have you proved it? With what evidence?
Well, the evidence of the fact that this was a grip that was not meant to be removed.
That's, yes. So, but clearly, it's in a place where people could do that, right?
Oh,
Gym members could do that, right?
But I would
So
add-
how have you excluded the fact that anyone could do that?
Because I would add to the point that it is LA Fitness's protocol.
No, I just want to know, what facts have you submitted to the court to exclude as a matter of law that someone could have touched that, not touched that bolt and loosened it?
The plaintiff's testimony that it was a permanent fixture to the apparatus. And therefore,
And that was disputed by defendant, correct?
it was not.
Oh, I thought the testimony of the gym people was that, okay.
No, Your Honor, that was pure speculation by appellant's attorney.
And what is the basis of plaintiff's statement? What is the bit, just because he uses the equipment?
He's a professional bodybuilder, who's been to that gym many, many times and used the machine many times. And it's not a scenario where there was a shelf of grips and handles and a wrench for patrons to come in and say, I like that one, I like that one.
Again, how do you know that you need I think I asked this to defendant, what evidence in the record says whether or not you can remove this with your hand or you need a wrench?
Mr. Zimmerman, on behalf of LA Fitness, was asked specifically what is done to maintain the nuts and bolts. And he said one scenario is with a wrench to make sure that the nuts and bolts are
No, but
tightened.
that's not saying that you can't remove it without a wrench. I'm asking you, what is the basis of your statement that you need a wrench to remove this, that you can't remove it without a wrench?
Common sense. And that's what res ipsa is. You know, if not, it speaks for itself. That is the Latin.
Sir, is there any tension between your position and the Court of Appeals decision in Barney-Yaboa, reversing our grant of summary judgment to plaintiff in a res ipsa case?
Absolutely. And it comes back to the point I was making first, is that it seems the distinction in this state is the invitation and accessibility to the public. So in the Barney case, the issue was that was on a subway. And the court held that it's just impossible to rule out that the thousands and thousands of passengers, the fact that that panel was exposed to vandalism, that was the issue. Here, this is a private gym. You know, there's no testimony, there's no evidence that any of these patrons would come in, bring their own grip, bring their own wrench, or that there was a display of grips and wrenches. That's the difference. And the Fickleman
counsel-
case discusses that.
I'm sorry. Did you want to follow? I'm just, you know, in the case that was just mentioned, as you say, Metro North or whatever, you have to go out of your way. People don't usually put their hands up. You have to go out of your way to put your hand up to the top part. And yet the Court of Appeals said that res ipsa applied to that. So we have a handle the handle is attached to something else, but the people are coming in and using a handle. It's like these pair of glasses, I may just put them on, but I'm holding it to put it on. If this one side fell off, I don't need a wrench to take it off. It's overuse, perhaps, but I still have, it's not within the exclusive control of someone else. If it's not within the exclusive control of anyone if somebody can touch it, is what I'm saying. So even if you don't need a wrench to undo it, is that's the issue we're asking.
Yes, I would argue, even if you don't need a wrench to undo it, it is still within the exclusive control of LA Fitness. And that goes to the second part of the analysis of why. Is because what's more likely? Is it more likely that this was a result of LA Fitness failing to maintain it? Or is it more likely the result of a patron, like I said, bringing in their own wrench, bringing in their own grip?
Thank you. I think we, thank you.
Thank you.
Your Honors, I think the Court of Appeals case Barney that Justice Higgett mentioned really is dispositive of this case, because in that case, there was even evidence from the defendant's own witness who testified that, to his knowledge, only MTA employees went into that area, the ceiling vent that came down and hit the person. So in that case, there was some evidence that the defendant was within some exclusive possession. The Court of Appeals still found that because it was accessible to the public in the area, that was insufficient. You could not grant summary judgment to the plaintiff in that case. In this case, the Fickelman case and the Pavon case.
Well, what about the Fickelman? Is the Fickelman case, as your adversary argues, is it on all fours here?
No, it's not.
Why is that?
Because it's factually distinguishable, because as the decision itself emphasizes, that the part of the machine that was alleged involved in the accident or defective or within exclusive control was too high to reach, and that you would need tools to go up and get it. In this case, it's not about whether you need a tool to take off this. It's whether people handling it continuously could cause it to have a defect in it or to come apart. And that's my point in this case. Your Honors, that also I do think a lot of this would have been resolved if there was some expert testimony about it, but plaintiff didn't do that. It's plaintiff's burden on this motion, and that's really all. Thank you.
Thank you. Walber, 82nd Street versus Fisher.
Good afternoon, Your Honors. Adam Pesca for the defendant, Dr. Andrew Fisher. This appeal is taken to seek reversal of a motion for summary judgment with respect to two judgments, one for representing arrears and one representing legal fees based upon an amendment to a lease, a second amendment to a lease that was neither fully executed or returned back to the tenant. In fact, in this case, the execution was fraudulent.
Why don't we talk about the full execution, because isn't the law that you bound by what you signed, whether or not you claimed you read it or didn't read it? Once you put your signature to something, you're bound by it? Isn't that well-established case law?
Well, I believe if you go to the formation of contracts and based on the concept of mutual assent, the person has to know the terms and the conditions of the contract.
But by signing their name to a contract, they are affirming that they are familiar with what they have signed their name to and have agreed to the contents thereof.
Well, based upon, typically, yes. However, in the affidavit from
Isn't there a number of
tenant,
cases that hold that if you sign something, you are bound by it? And to say, I didn't read it is not a defense to...
it wasn't that he didn't read it, he wasn't given it.
So are you arguing delivery, sir? Is that what you're
Correct, Your Honor. And even if it was given, it was never countersigned or
arguing? Are
returned.
you arguing delivery in this case? The delivery was never made? I mean, what precisely is your argument?
Well, both. The contract was never fully delivered before signing,
And was
it
there
was
a
not.
Was there a requirement in the rider that there be delivery for there to be a binding lease?
Well, I would believe so, because based on
Believe so, or you know so?
well, based upon the original lease that they're claiming, the 2004 lease requires that the lease be returned within 15 days and countersigned and returned within 15 days. They don't dispute in their opposition brief that delivery of the the countersigned lease took place during a holdover proceeding. It was the first time that Dr. Fisher actually saw.
How about delivery to the lender? Why wouldn't that be sufficient?
Because, well, it would be delivery, what's relevant would be the delivery to the tenant.
No, aren't there a number of cases that say delivery in this context doesn't necessarily mean I hand it over to you, right? It could come from both parties. It might not necessarily mean both party performing under it, but certainly other indicia like using the lease to get a mortgage or other indicia has been found by our court and many courts to satisfy the delivery requirement.
Well, he was not privy and did not know when there would be, and he was not even copied that there was any delivery to a borrower.
Well, I mean, he stayed in the premises and paid the rent and did everything that he was doing under the lease for the last 15 years, right? More than 15 years.
Correct.
Right? So he performed as if there was a lease, correct?
Correct.
Right. So the question then is, isn't it enough for the landlord says, I use this lease to get a mortgage, and that is sufficient to show delivery?
Well, the context of him signing was that they needed it to be signed quickly for financing. However, according to his affidavit, he states that we'll negotiate, we'll get a lease when you come back to New York. At the time, he was in London, England. So what did they do? They took the lease that he had signed, and they went and they fraudulently notarized it. The lower court just glosses over that, and this is for summary judgment. The facts are viewed most favorable to the non-moving party. That would be my client. So in that case, as far as...
You're saying there isn't sufficient facts in the record to issue a summary judgment?
Correct, that's it. And also, in getting back to your point, Your Honor, yes, there's a tendency. He was there in good faith, he was there for close to 20 years.
Well, is it your view that it was a month-to-month tenancy, or he was acting under a lease?
Well,
clearly he was there paying rent.
Right, sure.
Sometimes paying
Right.
in accordance with the Second Amendment, sometimes not. So
Sure.
what was it?
He was there as legally, under the case law, he would be there as a month-to-month tenant, and then therefore that the rent would be based upon the market value, and that's a question of fact to determine.
So he's not disputing liability, he's just disputing the number?
Well, correct. I mean,
Okay.
there's the issue of the arrears. You got a judgment for $185,000, plus a judgment for legal fees on top of that. I mean, that is on a summary judgment motion.
Thank you.
Anything more?
Thank you.
Okay, thank you, Your Honors.
Good afternoon, Your Honors. May it please the court, Allison Furman for respondent. The things that you need to know here is that the appellant does not dispute the fact that he, either through his entity or individually, was in possession of the premises from 2004 to...
No, he's just talking about the number. He's talking about the number. He's saying, I'm not a lessee, I'm bound as a month-to-month, and we should have had a hearing on fair market value over the period of at least the second term or of the lease, right?
Right.
Or the Second Amendment.
Well, we believe that he was a tenant based upon the Second Amendment of lease.
What about the delivery issue? What about the fact that it seems somewhat undisputed that Second Amendment was executed copy was never delivered to him? Isn't there a case law that says that delivery of the lease is required in order for the lease to be enforceable?
So let me take that one thing at a time. As far as the execution of the document, there's case law that's cited in my brief where this court has said that even if you don't get the document, even if you just sign a signature page, it's binding.
Okay, but
right.
there
So
are
the
two separate
delivery.
issues. One issue is whether he's bound by it, even if he didn't read it, or we just got the signatures page. But I'm asking you about the other argument specifically about the requirement of delivery under our law, that a copy of the executed lease has to be delivered. And how have you proven on this record that there was a delivery of the executed copy of the lease, which is required over and above the signature?
So in a couple of ways. The first is that in the email that accompanied the Second Amendment of lease to the appellant, the email said, we need to submit this tomorrow to our lender, and he acknowledges that he knew that it was for
Yeah, but
refinance.
that email is not competent, right? It's not admissible.
It's-
Did you put in, you would have had to put in what you showed to the lender,
Right, but
right? That email is hearsay.
but the appellant says himself that he knew that it was for the
Well, he knew
purpose
you
of-
said it, but in order to prove it, the problem is, right? That document's a hearsay document.
Right, but he acknowledges that he knew that that was the purpose of it. So it was delivered to the lender in connection
Well,
with...
was it? How do we know that?
Again, I believe that he acknowledged it.
Forget about what he acknowledged. It's your motion for summary judgment. How did you establish delivery?
Well, there
Forget
was...
about the 15 days, et cetera, et cetera.
The appellant acknowledges that he received a copy of it in connection with the holdover
He
proceeding.
received a copy of what?
The Second Amendment to the lease.
Signature page, which
No,
he
he
signed.
got the
He doesn't
entire...
acknowledge, his claim is that he received the executed copy of the Second Amendment during the holdover proceeding, not while the lease was still
So
in effect.
there's, if you look at there's page 190 to 191 of the record, and then 193 to 194, I believe, which is the email signature copy. First was the copy that was sent to the appellant, and the second is the copy that was signed. And if you look, there's a watermark on it that says page 4 of 4. So that, I believe that the entire document was sent to him based upon that watermark that says that there were 4 pages.
You didn't argue that below,
I didn't, that's correct.
right? Okay, all right, thank you.
Thank you.
Just one last
Well,
point.
actually, before you make your point, do you agree with counsel's statement that?
Yes, it was not in the record, Judge. I heard that statement.
Okay.
It was not in the record that he received the full Second Amendment to the lease. It was the signature page that was sent. And in fact, if you look at the full record, they had taken the position as if he requested it, he would have been able to review it. And that's not what the summary judgment motion, that was a motion for re-argue, but they took the position that had he requested it, he would have been given it, and he would have had an opportunity to read it. And part of that motion, there's an email saying, he's requesting a copy, I'm executing it, send it back. That's never done, it's not disputed. The only time he received a copy of the Second Amendment lease was during a holdover proceeding, which I should note, is 4 months after expiration of the lease.
Thank you.
all I have.
Thank you both. People versus Kenneth Martinez.
Good afternoon, Your Honors. I'm Benjamin Weiner on behalf of the appellant, Kenneth Martinez. Mr. Martinez's childhood was marked by significant trauma, which resulted in severe mental illness throughout his teenage years and adult life. And these circumstances both mitigate his conduct in this case and make a penal sanction a much more severe punishment for him. And this court should therefore reduce his sentence to the minimum of 5 years incarceration.
What do we do about the waiver?
Well, Your Honor, I think the context is really important. Mr. Martinez is a mentally ill person. His lawyer had concerns about his ability to understand the proceedings, and this is a virtual plea proceeding during COVID. So the court really had an obligation to be very thorough, more thorough than ordinary in describing the
Was there any
waiver.
question whether or not the defendant was lucid during that proceeding?
He had been deemed competent after a 730 exam, but again,
I just mean in the plea proceeding. Is there any question about?
Not specifically, Your Honor, but I think the Court of Appeals has directed us to look at the totality of the circumstances, and his struggles with mental illness are one of the circumstances here. And the problem with the appeal waiver is that the court never explains what an appeal is. I think it's second nature to all of us who practice here, to your honors, what happens during an appeal, and also what is quite confusing to an ordinary person, that a waiver of the right to appeal doesn't actually waive your right to appeal. It waives your right to raise
There a number of
certain claims.
prior convictions and the like in this case where he had some familiarity with the system?
Well, he had prior misdemeanor convictions and one prior felony conviction, but again, I think the court can't assume that that means that he understood the process. And again,
And
this
understood the significance of a waiver or an appeal. I mean, the fact that somebody's convicted doesn't mean they know anything more than the fact that they've been convicted, especially since we see so many errors here by judges and lawyers.
That's precisely it, Your Honor. And again, I would just emphasize, Mr. Martinez is somebody, he suffered severe abuse as a child. He bounced around through domestic violence shelters as his mother suffered abuse from romantic partners that he witnessed as a young child. This led to diagnosed hallucinations, psychosis, depressive moods at the age of 17 years old, a suicide attempt that left his arm and hand permanently disabled, and he continued to have these struggles really throughout his adult life. This is first diagnosed when he's 18 years old, 17 and 18 years old. That coincides with him coming out of foster care, being rendered without a home, navigating this really, really significant mental illness without any kind of stable support system. Still, he manages not to become addicted to drugs like his parents. It's true there are misdemeanors, but there are no prior violent felony convictions here. And we know, Your Honor, that Mr. Martinez is precisely the kind of person who will not get the kind of care that he receives, and that he will not receive the kind of care, that he needs in a state prison, and that he's likely to be especially victimized in that setting. 5 years is a very long time to spend in prison for someone in Mr. Martinez's circumstances. It is absolutely adequate to address the conduct in this case, which is violent conduct, no doubt, but given his circumstances, 5 years is enough. And so we would respectfully ask Your Honors to reduce the sentence to 5 years incarceration. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court. Jennifer Cavallas for the people. Defendant's excessive sentence claim is foreclosed by his valid waiver of appeal. Everything about this waiver indicates that it was made knowingly, voluntarily, and intelligent. The court asked him repeatedly if he understood what was going on, and he indicated that he did.
What about counsel's comments about the appellate aspect of what the court described?
About not...
About the appeal, that he'd be waiving his right to appeal
So this
without
court,
elaborating.
This court and the Court of Appeals has over and over recognized that the court is not required to make any particular litany about what is to be said. Explaining what an appeal is, how an appeal functions, is the duty of the defense attorney that was standing right there the entire time. And the defendant indicated that he was able to speak with his defense attorney and was satisfied with that representation. It's not the duty of the court to explain all of those things. What the duty of the court is during an appeal waiver colloquy is to explain that the right to appeal is separate and distinct from the rights automatically waived by trial, and that's exactly what this judge did here. The colloquy was very consistent, very clear, and very direct.
Well, it's more than just separately stating it. I mean, you have to talk about what the trial rights are as well, because then there's nothing to separate it from, and then what the right to appeal, what can remain to be appealed.
And then that's exactly what happened here, Your Honor. The judge fully described what rights are waived by guilty plea, and that colloquy is in the record and fully indicates what those rights are. And then the judge moved on to say, and your right to appeal is separate and distinct from the rights that I previously explained, and explained that the rights that survive a waiver of appeal, and then indicates that an excessive sentence claim is explicitly the kind of appeal that would be foreclosed by a waiver of appeal. So this waiver was very consistent, very clear. There is nothing about this waiver that would indicate that it was not made knowingly and voluntarily.
What about the fact that counsel indicated that this particular individual had some obvious issues that might have played with his ability to understand things, and that there was the judge didn't explain in any different or greater way
Absolutely. The court was fully appraised that defendant was struggling with mental health issues, but the 730 report indicated that defendant was completely lucid, as Your Honor indicated, that the defendant took pleas in the past that were favorable to him, and they were fully apprised of this mental health history, and that's likely the reason why all this mitigation is likely why the court agreed to dismiss other pending cases. There were 6 total misdemeanors that were dismissed, something that was going on in assault while incarcerated, and also to run 2 very distinct indictments concurrently. All of those very favorable assets to this plea was probably because of defendant's extensive mitigation that he cited, both by the defense attorney submitting letters based on his childhood trauma and the 730 report. All of that was fully considered, and because of that, there's no reason for this court to reduce the sentence any further, as the court was fully apprised of all the facts present, and a 7-year sentence is incredibly lenient and favorable considering all the things that were included with this plea, considering how violent this crime was. It was a random, senseless attack on an individual in the street where the defendant repeatedly punched the victim in the face, demanding them that they give all his money to the defendant, and then the victim suffered some injuries, and also there was a grand larceny attached to this that the defendant does not contest on appeal. So these are 2 very distinct crimes that were consolidated into one very, very favorable.
The other instances you mentioned were misdemeanors. Is that right?
Yes, the crimes that were dismissed as part of this plea were, it's unclear in the record what exactly they are. There were some.
Well, then I guess you shouldn't speak to how great a plea it was, bargain, if you don't know what it was that was.
Well, no, Your
dismissed.
Honor, because there was 6 different cases that the judge saying we're gonna dismiss these, 2 of which the judge indicated were domestic violence against his mother.
That's usually done, particularly when they're not significant.
Yes, and because of that, and then also dismissing the pending assault charge that was while defendant was incarcerated. Very favorable deal, and there's no reason for this court to reduce it now. Thank you, and we ask that you affirm.
Thank you.
So I think respondent has the right of it. There is extensive mitigation in this case. It's really, truly significant, and really, I think, contextualizes Mr. Martinez's conduct here. This court regularly reduces sentences in guilty plea cases that are negotiated.
Was this a favorable plea?
It was a favorable plea in the sense that it's true, Mr. Martinez was definitely facing more time, but it's certainly not a favorable plea when you consider Mr. Martinez's circumstances, when you consider his significant mental illness, when you consider the sexual abuse that he himself suffered when he was 14 years old, and when you consider what a carceral sentence means for him, what an additional 2 years in prison means for him. And so this is the kind of plea case where it is entirely appropriate for this court to reduce Mr. Martinez's sentence. I think respondent also pointed to this language. There's no particular litany in an appeal waiver. That's exactly right. That's because the court is supposed to tailor the waiver to the person that's before them, and that didn't happen here. Thank you, Your Honors.
Thank you. Thank you both. $214 Knickerbocker versus Pan.
Good afternoon. May it please the court. My name is William Chung, and I'm the attorney for the appellants. The court below erred in 3 major respects in granting plaintiff's motion for summary judgment. First, the respondent did not show by clear and convincing evidence that my clients committed actual fraud when they transferred the property. And the most important thing is that my clients did not know about the lawsuit at the time of the transfer.
Well, counsel, let me just ask you that as far as transfers go under the debtor credit law, there's this presumption of a fraudulent transfer where related parties transfer property that doesn't provide an adequate consideration in the transfer. And here you have the value of property nearly $700,000, and the parents have transferred it to their son from a mere $10. Now, I know that the sons paid half for that Smart Street property, but that's hardly something that seems comparable.
That's correct. I was actually addressing actual fraud under Section 276. But to answer your
Yes, but
question
I had a
about
different
273, the court below did not address the fact that there was a mortgage note that my client proved one of the transferees was solely liable on the mortgage for 80% of the property. So
What about the principle that past consideration cannot support an agreement unless the past consideration is explicitly in a writing? Where's the writing between the parties where there was an agreement that the son would pay the mortgage and that would affect the obligations?
well, there is no writing. But
So how can that be sufficient past consideration and based on the authority which says it has to be in writing to be adequate past consideration?
Well, I think our point is that the plaintiffs did not. The point is that the parents did not put in an equal share when they purchased the property.
That's not enough under the law.
That's correct. Maybe that
I mean, don't you need essentially, with respect to this point, a fair equivalent, right? That's what's necessary.
Correct.
And what did that occur here?
I mean, first of all, the parents gave up the sons promised to make payments to their parents from the rents collected from the property, but even if there was no fair consideration under 273, we submit that the court erred in finding that there was that the presumption of insolvency wasn't rebutted under 273, and that is because there's the case of In re Shelley, where a affidavit from the debtor as to their net
So
worth.
what did your clients put in? What evidence did your clients put in to rebut the presumption of insolvencies?
They put in an affidavit stating that
Their own affidavit that said we're not insolvent. But other than that, what else?
They didn't put in an affidavit that said they weren't solvent. They put in an affidavit that said that they had no debt at the time of the
Yeah,
transfer.
okay, that clearly isn't enough. So what did they put in their tax returns? Did they put in anything from their accountant? Did they put in any documentary evidence other than their own statements that they had no debt?
Self-serving statements.
That's all they put in. But I mean, we would submit that in the case of Shelley, the debtor did the same thing. They just put in a net worth statement, and that was all that they put in. But I would just like to address the point on actual fraud under 276.
Sure, okay, so let's go through actual fraud, right? What do you have to show? Close relationship between the parties. In this case, parents and child, right? Control of the asset after the transfer. The parents say they're still living in the asset, right? They're still living in the home, or they're still using the money, they're still using the rents for the home to pay their bills, correct?
They are not living at the property.
But they're still using that money to pay their bills, correct?
The sons were giving them money.
All right,
but they didn't maintain
still
control.
control the rents. They still control the application of the rents, and there's a close relationship between the two, and there's inadequate consideration. If you look at the case law, those three badges get you over the top, right?
Well, the court below didn't find that there was a retention of control, and it wasn't argued by the plaintiff in their moving papers. So that, so this is something that might have been raised for the first time on appeal, but it certainly was not the basis of the court's judgment below. I mean, the court's decision was based only on the fact that it was an intrafamilial no consideration exchange outside the course of business. But the retention, the right to get rent, not the right to get rent, but a promise to get rent from your child is not the same as control over the property.
No, counsel, as I understand it, the parents were getting some proceeds from the rents for their living expenses, et cetera, before the transfer, and the claim is that that relationship continued after the transfer. So their status vis-a-vis the property never changed.
And I'm going to let you answer that on rebuttal.
Correct. I mean, but
I'm going to let you answer that on rebuttal.
Oh, sorry. Thank you.
Good afternoon. May it please the court. My name is Alan Schwartz on behalf of Respondent 214 Knickerbocker LLC. Your Honors, this is a textbook fraudulent conveyance case. It's a case where a real property was transferred for $10 by parents to their sons.
No, wait, but it wasn't 100% transferred, right? Only 50% of it.
But the interest.
How is it let me just figure, let me answer this. How is it that the lower court tied up the whole property when it's clear that 50% of the property is owned by the non-debtors.
Your Honor, I think that the lower court's ruling tying up the whole property was in an abundance of caution to prevent any further transfers. I agree that the pre-existing interest that the sons had is not.
So what's their remedy? Do they go in and ask for partition, or what's their remedy in this case? Their property is being tied up. They're not accused.
But they're accused of receiving a 50% interest in the property for $10.
Right. So that 50%, we're all in agreement. What about the 50% that they own already? Why is that being tied up with respect to a debt that their parents own?
So, Your Honor, there is to some extent they have to the extent there's a money judgment against them as a result of the 273 and 276 action. Their interest in the property could be collectible.
Whose interest in the property?
The sons, to the extent that there's a judgment against them for money.
There is no judge. They're not even parties to the lawsuit.
But
How could they get a judgment against
Your Honor,
them?
what I would submit is that their 50% interest is separate and apart from the.
So in other words, can they at this point convey that 50% interest? Not the parents, but their original 50% interest. Under the order, certainly not.
Under the order, certainly not. I would understand if the court took the position that they could convey their 50% interest, and and the parents' 50% interest would be there'd be an injunction on any transfer of that. The court, I believe, the motion court was taking a cautious position on this, but.
So going back to the 276 actual fraud claim, your adversary says that you didn't argue at least one of the important hallmarks or one of the badges of fraud, and that is essentially the use of the property continued the same from before to after.
So, Your Honor, both the parents and the sons put in their affidavit testimony testified that they relied on the rents for their living expenses, and they testified to no other income, no other assets. Leading to the obvious conclusion that these rents were critically important for them to be able to pay for their living expenses. And then they transfer that same real property, and so it is a reasonable inference that they're retaining control of the property because they were completely reliant on those rents they were reliant on those rents to pay for their living expenses. And that's testified to by both the parents, and the sons. I hope that answers your question. Now, I want to raise one other point, about since we're on 276, I would just like to raise that one other issue, which is the timing of the transfer. This court has ruled that the timing of a transfer, shortly after, let's say, a lawsuit is pending or somebody's about to go into a nursing home, and before they go in, they transfer all their assets. That kind of transfer is presumptively. You can presume it's a reasonable inference.
Your argument that they don't even need to know about the lawsuit for you to be.
Yeah. Yes, Your Honor.
That sounded like you're arguing they need to know.
Well, Your Honor, this court's case law says that 276 applies to both present and future creditors, and so.
Right. So why are you arguing that?
I was just addressing the point that it's a reasonable inference that when somebody transfers an asset right after a lawsuit, like in this case, literally 20 days after the lawsuit was started, it's a reasonable inference that there's such that was a motivating factor in the transfer. It's just one of the badges of fraud. It's as we say in our papers, not all of the badges of fraud must be proven to establish a 276 case, and so we establish. That's just one of the potential badges of fraud to show actual fraud. Your Honor, going back to 273. As I said, this is a textbook case, and as I said, the parents testified that they relied on the rents. The sole claim here is that there was antecedent. The sole defense here is that there was antecedent debt, but none of the cases. There was the third department case that appellants cite is not a case where it was an intrafamily transfer, and that case was later questioned, or the third department later said that a conclusory testimony of antecedent debt is insufficient to defeat a 273 claim. And this court and the Second Department have repeatedly said that conclusory testimony of antecedent debt is insufficient to defeat a
But
fraud.
in any event, it needs to be explicitly recited in writing, correct?
That's also correct.
Thank you.
Thank you.
I just wanted to address the issue of control, and the retention of control. First of all, the rents were always being collected by the sons, who were the transferees, and that admittedly did not change. But the right to otherwise dispose of the property did change as a result of the transfer of the property.
By the way, did you argue below or here that the order was too broad because it should not have in any way affected the son's ability to alienate their interest?
You know, I'm not sure right now, but I would like to point out that, God bless you. But I would like to point out that with respect to retention of control, that certainly was not brought up by the plaintiff in their moving papers below. I don't think they raised it in the reply papers, but this was something that the court did not rely upon in making its decision. The court's very clear that she didn't believe that there's anything.
But in the affidavits, I mean, the parents discussed the issue in terms of how they were using the rents, isn't that right? So it was raised below.
The fact that they were getting rents from their sons was raised, but the
And
plaintiff,
that was the same before and after, correct?
that's correct. I mean, but the point is that the control was more than just the collection of rents, or the right to get rent, or the ability to get rent, because after the transfer, the sons could have sold the property if they wanted to. They could have mortgaged the property if they wanted to. After the transfer of the property, there was no reason to believe that it wasn't a bona fide gift, especially because they didn't know about the lawsuit. Okay,
So the bona fide gift, you say, did your client document that in tax returns showing that it was a gift and taxes were paid for?
Well, I don't know if they filed a tax return to that effect, but they transferred the deed, and on summary judgment, there's no indication that they didn't give up the right to sell this property. Or at least the sons did not give up, didn't have the right to sell this property, will otherwise dispose of it.
Thank you.
All right, thank you.
Thank you both. Ledesma versus Rodriguez.
Good afternoon, Your Honors. May it please the court, Herman Gruber on behalf of the appellant. The lower court misconstrued the facts of this case in that they thought that my client had suffered a prior injury, when in actuality, at his deposition, he was asked whether he had an accident, and he said—
Isn't the real issue that there were degenerative changes that were not addressed by your experts?
there were degenerative changes found by Dr. Springer, but not at the levels of the bulging discs that were found in this particular case by Dr. Lyons. Dr. Lyons found a degenerative condition at T12,
L1.
T12, and the herniations were L1 to L5. And also on the cervical CAT scan, the findings for Dr. Springer was at C4 and C6, and the bulges were C2 to C4.
But the question is that the report, the radiologist's report, did show degenerative changes. Did you address, or did your client address that on summary judgment?
No, Your Honor, but I believe that everything has to be taken into in totality. I mean, the accident, there was no prior condition, there was no prior injury to Mr. Ledesma until the accident happened. The exam—
Okay, let's assume that that's true, that the judge did, because I didn't see that the judge took the prior into consideration. Let's just say it's the two posts that are in.
Well, if I may, Your Honor, the entire decision was based upon the belief that he had a prior accident, and and the court basically dismissed the two treating physicians' affirmations because they didn't ask him whether he had, or didn't address whether he had a prior accident. He didn't have a prior accident.
Okay, so let's look at it from the position that you're saying, that he didn't have a prior accident, he had two post accidents.
Correct.
Still, there's this issue that you're moving for summary judgment. I'm sorry.
No, the defense
The
counsel
defense
made a
counsel
motion.
moved for summary
But they
judgment.
never even addressed the issue whether of a prior accident or a subsequent accident. So
But there's
based
still these issues with regard to the degeneration, and I know you're saying it's particular, L12 or whatever it is,
Right,
but
L1
the
through
point
L5,
is you
but
haven't
Your
addressed
Honor,
that.
I mean,
So there are
essentially,
questions of fact then that haven't been.
it is a question of fact.
I'm
and
sorry.
That's exactly my case.
I'm sorry, I'm sorry, I misspoke. There are issues that were not addressed here, that you weren't able to raise an issue of fact if your own radiologist wasn't addressed, plaintiff's own radiologist.
But essentially, almost everybody over the age of 40 has some degeneration going on in their spine, Your Honor. I mean, there was no complaints concerning his condition prior to this accident.
But Counselor, what we were asking you is, and I agree with everything, unfortunately, you're saying, there is degeneration, but did your doctors address that and address whether or not it was a cause of his injuries? That's the only question we're asking.
No, Your Honor, I don't believe that they did. I don't believe that the degeneration in and of itself was the reason for the findings that both the plaintiff's treating physicians found. And I believe there was
but
a
didn't here's defendants experts say these are not causally related to the accident, they are degenerative in nature. So the defendant puts up their prima facie. Did your experts respond to that and say, no, they are not degenerative, the degeneration did not cause the injury here?
Not the radiologist, but both plaintiff's treating physicians did.
Said that, so you're saying now they did address the
Well,
argument?
no, they
that
didn't
degenerate-
address specifically that there was degeneration found in the
So
spine, but
that's what
they
I'm just
did
saying.
believe that
Did they address that?
excuse me,
Did they address that?
the degeneration issue? No,
Okay.
not at all.
Is that fatal to your claim?
I don't believe so, Your Honor.
I don't know.
I'm sorry, I don't believe so. Again, we're looking at people who are involved in car accidents over the age of 40, and then there's going to be degeneration in most MRI or CAT scan findings.
Thank you.
Can't
That may be true, but this is a legal issue, and you have to address it. If the other party says you shouldn't have, they're entitled to summary judgment,
Well,
there's degeneration, and then you don't address it.
Right. With all due respect, Your Honor, I mean, the plaintiff's treating
we
physicians
understand your
believe that
position.
the causation of the range of motion loss was based upon the car accident. Thank you.
Thank you, thank you. Carr versus New York State Division of Housing.
Hi. Good afternoon. May it please the court. My name is Harry Levy, and I'm here representing my wife, Leslie Carr, and myself. Leslie's a retired college textbook editor. I'm a retired public health doctor. I'd like to discuss 3 places in the DHCR order where we believe the order did not rationally apply the HSTPA. I'd like to then discuss DHCR's disregard of the State Administrative Procedure Act. First, HSTPA made mandatory an award of reasonable attorney's fees and costs to any tenant who was overcharged, which Regina specifically noted applied to our claim. The plain text of Part F4A4 on attorney's fees has no exceptions. DHCR misinterpreted HSTPA by using the wrong standards to make an award that disregarded whole phases of this proceeding. In so doing, the order creates an irrational and arbitrary result for every tenant who initiates an overcharge complaint at the DHCR. What's more, the order arrived at this determination by arbitrarily and capriciously refusing to look at the evidence of attorney's fees that we submitted, 144 pages, which DHCR does not deny. If you don't look at the evidence, a determination cannot possibly be rational. Second, With respect to fraud, DHCR misinterpreted Part F4A, which expanded the definition of fraud, a definition Regina acknowledged and did not disturb. Instead, DHCR's order and brief to this court conflate the improper but not willful deregulation of the apartment with landlord acts after the deregulation. And the order did not consider this fraud evidence, including acts within the look-back period, that this court has ruled unlawful pre-Roberts. Therefore, this order in respect to fraud is not rational. Third, the order's prospective rent scheme and calculation of so-called arrears violated the guidelines of Part E 214. This order also ignored Regina, which clearly stated its decision had no prospective application. The legislature amended the rent stabilization law to make Part E 214 apply to, quote, any tenant, end quote, entitled to a renewal lease as of June 14, 2019, not as formally only to those tenants with preferential leases. The DHCR's calculation of arrears reflects two contradictory orders. The first order in February 2021 said the landlord didn't preserve his entitlement to higher rents with just one lease's notations. While the November order, now before this court, said that the landlord had made handwritten notations on every renewal lease to preserve his rights, which is false. There was no landlord notations on every lease, only the first. It's another instance of the DHCR not looking at the evidence in the record. Neither DHCR nor the landlord has denied this. In fact, in the brief to this court, the DHCR now disavows its reliance on these renewal lease notations. It introduces on page 17 of their brief a brand new explanation that the owner was not required to make any notations on the renewal leases to preserve the higher rent. These constantly shifting explanations are, in my mind, a textbook example of arbitrary and capricious. Arrears were not contemplated in the HSTPA. They were not contemplated in Regina. They were not considered by this court in 2018. What happened here was that the order improperly, once again, conflated, here's something else, rent stabilization with rent control case law. It's conflation because in rent control, quote, and this is from the DHCR's own fact sheet number 1, owners are not required to offer renewal leases as tenants are considered statutory tenants. Now, turning to SAPA. Regina relied on RSC 2526-1A3I to determine the base state rent. DHCR has offered no evidence that it followed the mandatory Section 207 parts of SAPA protocols for reviewing an existing rule and maintaining its validity. Mandatory reviews are required at least every 5 years after adoption so that comments from the public are gathered and assessed and then published in the New York State Register. The chain of compliance for this rule has been broken since at least 2005. When challenged, the DHCR, rather than acknowledge its actions, dodges the issue. DHCR offered no evidence about reviews in 2005 or 2010, and instead misrepresented to the lower court, and again in their brief to this court, their compliance with SAPA as part of a, quote, 2014 amendment process, end quote. DHCR then further misrepresented to this court that in its 2014 amendment process, that was confirmed by this court's second department in Portofino Realty versus DHCR. That's also, they're all conflations.
I want you to know that you have a little less than 2 minutes left.
Excuse me?
You have a little less than 2 minutes left. I just want you to
thank you.
understand what the white light is.
Thank you. The 2014 amendment process documents do not mention 2526-1A3I, which DHCR does not deny. And Portofino ruled on newly adopted rules, not existing rules, newly adopted rules per a different section of SAPA 202 that established the tenant protection unit. Portofino never considered this existing rule at all. The order's failure to consider the validity of this rule was arbitrary and capricious and not rationally based on any supporting evidence. Because of the issues we've raised, we respectfully ask this court to reverse the decision of the lower court. I'm happy to answer any questions you might have. Thank you, and If you don't have any questions, reserve whatever is left of those 2 minutes for the rebuttal.
You have 2 minutes of rebuttal,
Okay,
full 2
thank you,
minutes.
Your Honor.
You're welcome.
Good afternoon, Your Honors. Chris Hasse from the DHCR. DHCR's power order being challenged in this proceeding is rational and consistent with the Court of Appeals decision in Regina Metropolitan.
I'd like you to explain how you arrive at your calculations.
Yes, the Court of Appeals decision remanded with a directive that the calculation of the base date rent would be the rent charged on the base date, which in this case was $5,195, which is the amount which the tenants had agreed to pay in their initial lease, which was executed in earlier on in 2005.
And explain the difference between that number and the 4,088 number or whatever.
Yes.
That
That actually touches into the fact that this has been litigated extensively. That the 4,000 figure was the rent established by the initial rent administrator's order in 2014. That order was
The
part.
landlord offered that, was willing to pay that amount, but under protest, is that right?
Yes, what happened is after that point, the landlord was paying that amount. There was no stay on that order. Even though a PAR was filed, the stay does not stay prospectively the rent that the owner could charge. As a result, he complied with that requirement and charged the rent that the district rent administrator determined and added guidelines.
And as I said, it was under protest, so subject to whatever the Court of Appeals determination.
Yes, Your Honor. The expectation was that he was litigating at the time he
And
was.
so based on the Court of Appeals determination,
Yes.
that number is not the number. It has
Correct,
to be
Your
the
Honor.
$5,195 amount.
That's right.
Okay, so you were explaining, start there.
Excuse me?
You were explaining how you arose, how DHCR has arrived at its calculation.
Right, Your Honor. There was a remand, and there were specifically fined directives by the Court of Appeals to use the rent charged on the base date the rent charged on the base date as the base date rent, which at that point would commence the calculation of the legal rent. And to that amount, the court at 35 New York 3rd, 354 and 357 clearly states that that amount would then be used with all the legal increases the owner would thereafter be entitled to. And the calculation that was done in the challenged order, that is what the calculation consists of. Now, prior to 2014, the tenants there were several points when they were overcharged, and that is the only time they prevailed. After that point, they had continued, as they were able to do, as they chose to do, to pay the lower rent, knowing that this was in litigation, and they were at that point represented by a very competent counsel. But from that point, there is a discrepancy that occurred between the legal rent and the rent that was paid. And that would eventually amount to what is termed as the arrears. But arrears only occurred because of the recalculation of the legal rent, which goes back to that change in the initial base date rent. My position with HESPA and many of the claims that the appellant has raised just now is that they are improperly raised as re-arguments to the Regina decision. There was opportunity to raise many, if not all of these. We disagree, and I think the tenants chose not to re-argue Regina, while some of the tenants did, and their re-arguments were denied. There was a question as to whether prospectively, from the effective date of HESPA, there should be a different calculation. That was raised just now. That was raised by other tenants, and that was denied. Regina did not remand for that reason, and the division complied with the order, and the award of legal fees was rationally based on the evidence submitted during the RA and the fact that the tenants had only prevailed during that part of the RA proceeding. If there are no further questions, we ask that the lower court's order be affirmed.
Good afternoon. May it please the court. My name is Jillian Bittner, and I represent the landlord, Regina Metropolitan.
How in this case did the owner preserve its right to the higher rent?
Sure. So Part E of the HSTPA, which appellant argued is applicable and would give a preferential rent for the life of the tenancy, is based upon the rent administrator's initial order issued in 2014 that erroneously awarded a rent overcharge in the amount of $280,000 and set the rent at $4136. That order was ultimately completely reversed by the Court of Appeals. So the difference in the calculation was during the pendency of the litigation, that is from the point that the rent administrator's order issued in February of 2014 until the Court of Appeals remanded, the landlord had no right to charge or set any other rent than the rent based upon the rent administrator's order plus applicable rent guideline board increases upon renewal. The tenant's argument that this wasn't preserved is notably undermined by the fact that the parties, at this point both represented by counsel, entered into a stipulation that stayed enforcement of the award issued by the rent administrator in 2014 so long as the owner agreed to deposit the amount of the overcharge into escrow, which it did, and which amount after the Court of Appeals decision was ultimately almost entirely released. Until DHR's determination on remand, had the owner sought to charge the higher rent, that is the rent $51.95 on the base date plus the increases, the owner would have exposed itself to treble damages because it would have willfully not complied with the rent administrator's order, which, as DHR mentioned, there was no stay of that rent. There also was uncertainty at that time. As this court is aware, there was a question as to how to set the rent, and that remained outstanding until the Court of Appeals issued its determination, which directed DHCR to accept the rent in the lease on the base date, which is $51.95, and apply all lawful increases. The appellants do not allege that DHCR failed to comply with the Court of Appeals order that directed application of that section, which is 2526.1A3I. What the tenants are seeking to do is to collaterally attack the methodology because it ultimately resulted in an overcharge of $9,200, of which the legal fees awarded were $26.67. That's 30% of the ultimate total overcharge. That is not unreasonable. That is completely rational and not arbitrary and capricious. I would add to that the HSTPA, although making an award of legal fees compulsory instead of at the agency's discretion, which it has always been, it still leaves the word reasonable in that section under the HSTPA. So to issue an award of any amount more than the $26.67 would not be reasonable when the total overcharge is $9,200, and that's not excluding interest, which was around $9,000 as well. As to the issue with fraud, there is no room for this court or any court to review the issue of fraud. The case on appeal now was heard and decided to finality by the Court of Appeals. They considered this exact appellant's rent overcharge claim. They considered it from 2009, which is the base date, which was the date of the filing of the complaint, through the current date. They conclusively determined that the HSTPA was not applicable to the processing of the rent overcharge complaint. The court also held that there was no fraud. This was a post-Roberts overcharge claim. As is typical in Roberts cases, there was no willfulness finding and there was no fraud. Thank you.
Thank you. Gar, you have 2 minutes.
Thank you. We never challenged the Regina decision in terms of the setting of the Bay State rent, and Regina limited itself to that in its decision. Thereafter, the HSTPA applies to all the other issues, as Regina said in footnote 29, and the DHCR essentially confirmed it by awarding us some legal fees, not what we wanted, but some legal fees, after Justice Schlesinger in the first Article 78 felt the whole reason not to give us legal fees was irrational, essentially, but she had no choice except to defer to them. And in terms of, you asked, the court asked Ms. Bittner, how did the landlord maintain his right to the higher rent? And the DHCR said that it was first not maintained by this notation on the lease.
Well, how about the stipulation?
Excuse me?
How about the stipulation referenced by counsel?
The stipulation about the $280,000?
The stipulation referenced by counsel in terms of how the mechanics of how the parties would proceed, would that be sufficient?
No, because the landlord was whining that this $280,000 was a terrible, terrible thing that was causing them a lot of problems. And really, out of the kindness of our hearts, we said, okay, put it in one of those funds and we won't deal with it until the whole thing's resolved. It in no way shows that it resolved anything except we were, being nice to them. But the only lease that they actually put a notation on is the very first one. And that one specifically relates to mentions a rent of $4,301.77, and it's a 1-year term lease. Thereafter, they never put any notations on. I think my wife and I had every reason to think that was the end of it. We didn't know this went on ad infinitum. They abandoned those notations. And the other point that I think is important about fraud, the HSTPA expanded fraud. I know you had another case recently, Burroughs, in which you said it didn't apply fraud, but that was a look-back period fraud. We had fraud of J51 riders that were false. We had a rent stabilization registration in 2007 during the look-back period that was false. These are all things that this court, in other cases, East West Renovating, has said this constitutes fraud. So we have fraud by all the criteria of the HSTP and Regina. And no one has answered yet the SAPA thing. The SAPA thing is real. SAPA, we follow the procedures in SAPA, section 205, which says how to appeal a SAPA contention when you think something's not valid. We did it exactly the way we were supposed to. Thank you, Your Honor.
Thank you. Thank you all. Marion Scott Real Estate versus River Bay. Yes, of course.
Good afternoon. May it please the court, Jennifer Redmond for the appellant, Marion Scott Real Estate. We're here today about the lower court's decision on reverse summary judgment in favor of River Bay, the owner of Co-op City. The main point that's before you today is whether or not Marion Scott is responsible for the employment contracts. I can argue at length about why the codal decision shouldn't have been used in the lower court's decision granting reverse summary judgment.
Can you answer a question?
Sure.
Is there any dispute here that there was an unlawful overtime policy?
No.
There's no dispute?
No dispute.
Okay, go on.
Where in the record, I know you spent a lot of time talking about the res judicata effect and the settlement, but where, if we wanted to determine whose policy this was to charge, to do things this way. Where would we find that in the record? Because I've looked and looked and looked, and I don't really see anywhere in the record that really addresses who ultimately made the determination between the two parties as to how this, or whether this policy should be implemented in the first instance.
That's an excellent point, and the reason you don't find it in the record is the parties have never gotten to the point where they have litigated that issue amongst themselves in this litigation.
Has there been any depositions,
There's
document
been,
exchanges,
so
et cetera, on this issue?
what the parties contemplated in this litigation was a counterclaim on the apportionment of liability on the collective bargaining agreements in the federal court labor case. In the federal court,
But just so I want to understand, does the collective bargaining agreements specifically address this issue of overtime versus comp pay? Is there a specific collective bargaining provision that addresses?
so I'm going to say two things. I was not counsel in the federal court case, and I say that because in this case, there is no dispute that the employment contracts did not properly allocate comp time, and they did not comply with the FLSA or New York labor law. We're not
Contracts themselves.
they're collective bargaining agreements.
Okay.
So the River Bay employees were all governed by these collective bargaining agreements. That's what's at issue in this case as to who's responsible for drafting those collective bargaining agreements. If we say for argument's sake, they weren't drafted properly and they absolutely didn't adhere to New York labor law or the FLSA, the question then becomes who's responsible for that? And the lower court decided that Marion Scott was unequivocal.
So what's wrong with what the lower court did, saying that Marion Scott was responsible because that's what the management agreement said, that Marion Scott was going to be responsible for these contracts?
First, the managing agreement doesn't say Marion Scott is responsible for the collective bargaining agreement. And secondly, the statute was misquoted by the lower court. It also doesn't say Marion Scott is responsible for the labor contracts. And most importantly, Marion Scott wasn't responsible for the labor contracts and didn't draft the labor contracts. Marion
Are we
Scott is
talking about who merely drafted the legal contracts, or are we talking about who discussed and came to determination of what that policy would be?
the policy as to
The comp time versus the cash.
the collective bargaining agreements were explicitly farmed out to Labor Council. The concept is that you have a managing agent running Co-op City. Your managing agent isn't the person who's drafting collective bargaining agreements. I can't think of any circumstance where a managing agent would be drafting collective bargaining agreements. No managing agent would take that on. I'd venture to say Douglas Elliman hasn't taken that on either. So the concept that the managing agent drafted the collective bargaining agreements and now is responsible for them is not anywhere in the record. That's why they didn't move for summary judgment to begin with.
There's nothing really in the record about who was responsible for collective bargaining.
There's two places, well, there's three places. The first place is the managing agent contract, and the managing agent contract requires MSI to oversee, but does not require MSI to draft these collective bargaining agreements. They have to make sure employees come to work. They have to make sure they're paid according to it. They don't pay them either. They're only responsible for overseeing, not drafting. And the board decided to hire Travella and Forte, Labor Council, to draft these agreements. The president of the board explicitly said, we hired Travella and Forte. So now what the lower court did was, in light of the fact that we didn't brief it, it was never moved on summary judgment, this was reverse summary judgment, there was no opportunity to correct all of these issues in this lower court decision. The statute's misquoted. The actual statute that Justice Leibovitz quotes in the lower court was actually from board meeting minutes from River Bay. That language was not what the 1729 3.3 states. 1725 3.3 states. very importantly. Secondly, throughout that decision, he says Marion Scott is solely responsible for the labor contracts. It's not in the managing agent agreement. It's not in the statute.
Nobody was moving for summary judgment on these issues.
He didn't move for summary judgment on it because he would have lost if we had the
You didn't move for summary judgment on that issue either.
We didn't move for summary judgment on the issue of whether we were responsible for the employment contracts because it was never an issue to move on. It was not part of the counterclaims. And I think both parties contemplated we would probably have to relitigate the underlying federal court case vis-a-vis the defendants, because that's the apportionment of liability regarding the employment contracts. This is why there's no record of what the CBA says, because it was never something, they didn't move for summary judgment on the CBA. So that's why it's not in the record. We never had a reason to talk about the CBA and what was in it and who was responsible for it.
Is that something you would normally, if this had not happened, would have discovery on?
I think the parties both agreed that the CBA, for the purposes of the damages, the CBA was drafted in a way that didn't comply with the labor law or the FLSA. It was drafted by Labor Council. So ultimately, the question would be who was responsible for drafting them, not for overseeing, which is two different questions, because you're putting on a managing agent the responsibility that Labor Council had. And the board,
But Labor Council is not going to ultimately be the one who's liable. It's going to be one of you two.
and the board hired, the principal, River Bay, hired Labor Council.
I mean, Labor Council only does what the client wants. So the question is, who was responsible for the policy, River Bay or the management company, isn't it?
Well, it has to be River Bay because they hired the council to do it. Even if you argued, and I wouldn't argue this, but even if I said, okay, Marion Scott had to oversee it, they didn't. The owner came in and said, you're not going to do it. We're hiring these guys to do it. Rightfully so. They were Labor Council.
Why didn't you move for some, if it's so clear cut, why didn't you move for summary judgment on that issue or make a claim on that issue that as a matter of law, you could not have any liability for these amounts because you were not involved in the negotiation of the collective bargaining agreements of what would be contained therein?
We moved for summary judgment on the breach of contract claim on the termination.
Right, but not on this issue.
We didn't have damages on this issue because we're not responsible for the underlying labor claim. We're not responsible for the CBA or the underlying federal court action. So we didn't have
move to dismiss the counter.
We did move to dismiss the counterclaim.
Oh, and that's when they granted reverse.
Right.
Okay.
Correct. Thank you.
May it please the court, Mike Cater on behalf of Respondent River Bay Corporation.
Okay, let me immediately ask the question then.
Yes, ma'am.
If this policy was in the collective bargaining agreements, then how is, as a matter of law, the management company responsible for what was contained in the collective bargaining agreement?
Thank you for that question, Your Honor. I believe it was you that asked the previous question on the appellant about depositions and who was responsible for the management. I personally conducted the depositions and the discovery. And when I deposed the principal of Marion Scott, he was in charge of managing of the Labor Council. And that's the truth.
Wait. He was in charge of managing Labor Council. What does that mean? What do you mean by that?
Yes, generally speaking.
If I hire a lawyer and a lawyer says to me, here's a good contract, how does that as a matter of law make me responsible for damages?
Because the appellant, Marion Scott, was charged for the daily operations and an employee.
But if you have a contract drafted by Labor Council, hired by River Bay, that says, here's a good contract, enforce it, how am I responsible for enforcing a contract that you've told me to enforce?
If you look at the record, I believe it's 921, it states that MSI was also part of that contract.
Did River Bay hire the lawyers who wrote the contract?
River Bay voted on the contract.
So River Bay is the client, right? Marion's not the client. River Bay is the client.
Correct.
Client, right? The lawyers, draft contracts and hand them to River Bay and say, here they are. How does now Marion become responsible for the fact that the lawyers didn't comply with the FLSA and state labor law? How is that Marion's responsibility as opposed to yours, the client who hired the labor counsel who drafted the contracts?
Thank you for that question. Pursuant to the record, MSI was working hand in hand with Labor Council. MSI also, not just with Labor
Let me
Council,
go back
any
a second.
contractor.
Let me go back even a step further, because none of this is discussed by the decision below, and none of this was the rationale for the court's decision below. And the record that we have on appeal really does not fully flesh out the issues that we're arguing about today in terms of how this got into the collective bargaining agreement, who caused it to get into the collective bargaining agreement. So, and it wasn't the rationale for the court's decision below. So how can we, on this record, affirm the court's granting of summary judgment when even the things we're arguing about today have nothing to do with what the court decided?
Well, it's not in dispute that MSI was in charge of all employees and its contractors.
So you're saying they were implementing the policies, correct?
Absolutely.
Whose policies?
Exactly.
Was it MSI's policies? MSI was in charge from the basic minutia of scheduling. Who gets a promotion?
So
who works where.
MSI does not speak, promotion, maybe that's something else, but MSI doesn't not speak with River Bay about what River Bay wants for its company at all. That's what you're saying.
Frank,
They have no
MSI
conversations with River
I
Bay.
apologize, Your Honor, for over-talking. To be quite frank, MSI should have been speaking to the board, and the board was left in the dark. We found out about a lot of the malfeasance quite by accident. You know, it's not in...
Wait, aren't you the client who gets the contracts from the lawyers that you hire? How could you be in the dark? Isn't that on you?
No, DHCR prohibits from the board of being involved in the daily operation.
No, I'm not
This is not daily
You hired
operations.
This is not, right. You hired the counsel who worked on the collective bargaining agreement. We're not talking about, who got promoted to superintendent. We're talking about an overall policy in the collective bargaining agreement about how people would be compensated. That's very different than day-to-day operations, making sure people get their paychecks. And what we're trying to figure out as a bench is who was responsible for the overall policy in the collective bargaining agreements about how people did or did not get compensated.
I understand the question, and that wasn't addressed during the oral arguments, but it's the board's position that the managing agent is responsible for all implementation and
Well, I can
policy.
understand why it would be the board's position that that's the case, but I don't know that the record bears that out.
So in other words, you can retain counsel, you're given the policies, they implement them, and you have absolutely no responsibility under those circumstances?
We should have been more informed of what was going on in negotiations, not just with this contract, in all contracts, from insurance to labor or anything else. But unfortunately, MSI wasn't keeping the board apprised of such things, which is not in dispute.
You never saw the collective bargaining agreements?
I'm sorry, Your Honor.
Your client never saw the collective bargaining agreements? Or got copies of the collective bargaining agreements?
Not to my knowledge.
Doesn't this...
Is this in the record, any of this? Before us?
The collective bargaining agreement?
Yeah, and who got copies of the collective bargaining agreements? Who was involved in the negotiations for the collective? I mean, you're asking us to decide something on this appeal that it does. None of this seems to be in the record that we have to decide it with.
Well, the reason why I believe that it didn't come up, because it wasn't in dispute that MSI was in charge of contracts. Even if I misquote, anything over $100,000 should have been approved by the board, and MSI didn't do that. What was clearly a misstate on the record during the deposition, where the board president says, yes, we hired. The next question, if you go down, says, and who was in charge of that process? The answer was, by the same witness, MSI. So MSI can't come here and say, hold on one second, we're making all this money, We had nothing to do with it, and too bad, so sad.
No,
You
no,
can't come to
but the
court with
question
unclean
is
hands.
not, it's whether you get reverse summary judgment on a record that doesn't even show who's responsible for the collective bargaining agreement that is the basis for the unfair labor claims, right? You got summary judgment for unfair labor claims on a collective bargaining agreement that we don't even, at this point, have definite information in the record as to who paid for its drafting, reviewed it. None of that.
Well,
Is any of that in the record?
well, in the record, the lower court discusses the contract, the regulation.
No, I'm asking you about.
The CBA, no.
This policy wasn't made up. It came from an agreement. It's not Marion's personal policy. It came from a collective bargaining agreement, correct?
Correct.
And somebody drafted and reviewed and decided that that was okay, correct?
Correct.
And we don't have any indication in the record as to how that process occurred, correct?
Somewhat.
Okay, thank you very much.
You know, if I could say, but what's not in dispute, Your Honors, is that MSI was in charge of all employees and contracts from implementation to conclusion.
Thank you.
One very short point.
Okay, 2 minutes.
The president of the board, and I'm quoting from his deposition, board of directors had engaged a separate law firm, labor law firm, to do the negotiation with labor issues. Okay, what law firm was that? Scott Travella, the law firm of Travella and Forte. Does that sound correct? Yes. The board hired the firm to do the labor and to do the collective bargaining agreement for the simple reason that that's who was expert at doing it. Nothing further. Thank you.
I have a question.
Yes.
Did the board approve the CBA? Is there any evidence about that in terms of board deliberations, approval of the CBA?
I don't have the board had to have approved the CBA, but I don't have that in the record as we sit here today. Okay. And much of what counsel said is not in the record at all. In fact, none of it is in the record for the obvious reason that it was reverse summary judgment. None of it was briefed. Thank you for your time today. I appreciate it.
Thank you both. Sinal versus Lynch.
Good afternoon, Your Honors. Tanya Mistretta for Defendants Appellant, the Archdiocese of New York, and Mary Lynch, and may it please the Court. The plaintiff's claim of retaliation under the New York labor law and his claim for breach of contract premised on an employee handbook should have been dismissed. The defendants did not employ the plaintiff, and the plaintiff fails to plead claims against the defendants in the complaint.
Did you utterly refute that claim?
So in addition
Motion to dismiss, right?
In addition to the complaint failing to plead claims, yes, the documentary evidence additionally refutes the plaintiff's claims.
Is there other documentary evidence that may suggest it's not utterly refuted? You know, wage statements, pensions, all that thing?
Yes, so the plaintiff did produce on the record pay statements, which actually represent that he was employed by Central Services, a distinct corporate entity from the Archdiocese. Plaintiff alleges on opposition, however, that Central Services does not exist and that it's merely a payroll account for the Archdiocese. He makes this claim based on a statement allegedly communicated to him by his counsel. In fact, the documentary evidence wholly refutes his claim and demonstrates that Central Services is a distinct corporate entity. We produced the certificate of incorporation on the case. Additionally, the plaintiff, even if he could establish that defendants were employers, and I do think it's worth noting, the plaintiff does not allege any facts regarding Ms. Lynch. There is nothing on opposition. There is nothing in the record. Plaintiff has conceded the point. Ms. Lynch should be dismissed on that basis alone. However, even if the court were to consider the defendant's employers in this case, the plaintiff still fails to plead viable claims. In particular, he fails to allege a claim of retaliation under the New York labor law and fails to support a breach of contract claim.
So he complains about this practice. There's an investigation that goes on for what, 2.5 years?
No, Your Honor. The investigation was concluded on July of 2018. In fact,
when was the complaint made?
The complaint was made in or around of February 2018. Within several months of that, the investigation is wrapped up, and the plaintiff remains employed for an additional 2 years, 2.5 years, almost.
The report was issued in July 2018?
Yes, it was, Your Honor.
Is that in the record?
The report is not. That fact is in the record. I see my time is up, if I may respond to that point. It is in the affidavit of Roderick Cassidy, the date of the report. It was July 2018. Additionally, the breach of contract claim based on an employee handbook has no merit. The well-settled rule here is that a handbook is not a contract. While there may be a basis to rebut that presumption, if the employment is for a fixed term and if there is some form of detrimental reliance, none of those facts are alleged in the complaint. And here, the handbook also has that key disclaiming language that the Court of Appeals held in Labasco prevents implying any contract based on a handbook exists.
Thank you.
For these reasons, we ask that you please reverse. Thank you.
Thank you. People versus John Arias. You may begin.
Good afternoon, Your Honors. Will Page, Office of the Appellate Defender, on behalf of Mr. John Arias. On the most critical point that was in front of the grand jury, the prosecution elicited a completely different set of events for the 2016 grand jury than what happened before. And that completely material and prejudicial change in testimony went uncorrected. The trial court, during the motion to reinstate, after it had dismissed this overcharged top count, was never informed that there was this material variance between the sole witness's testimony. Yes, Your Honor.
The grand jury has broad powers, and here, I mean, I think overall what's necessary is that they have reasonable cause to believe that the crime took place. And in both grand jury proceedings, it's that the group beat up the individual, the decedent. One is, I think, you'll correct me if I'm wrong, that they beat him up and were holding him when he was shot. Another is that they beat him up and let him go. He slumped down and then was shot. Those the two differences there?
That's essentially correct, Your Honor. There's a slight difference in that I think that the overall tenor of the 2014 grand jury presentation, the first one, is that it's really a street brawl. It's a free-for-all. And it's those inferences about intent, right, that the Court of Appeals talks about in Badassure, that's for the jury when they're making that calculus. And they didn't have this critical difference in front of them.
So in both, the testimony in both is that the person, Washington, I believe, comes up to Levon, I think is the name. And
Mr. Wayne Harris is the one with the gun. And
Harris, I'm sorry.
No problem.
Harris comes up to Levon, and then the cousin, the decedent, steps in, and then the group starts to beat him up so that Levon can take care of business, presumably, with Mr. Harris. And then they're continuing to beat him up when now Levon turns on Mr. Washington. Isn't that consistent throughout?
When Mr. Harris turns on Levon.
When Mr. Harris, the shooter, I'm sorry, when Mr.
Turns on
Harris
Darrell. Yes, Your
turns
Honor.
on Washington.
Well, I think there's...
Isn't that consistent? He's talking to one, they're beating up the other one who tried to intervene.
Well, in
He's
Levon's
done
own
talking
words.
to one and then turns around and shoots the other.
Well, in Levon's own words, he's talking about they're battling. They're battling big Darrell. So, I mean, this is not like, and in Wayne Harris's confession, he talks about that he runs up because someone's in a headlock and he's getting involved in it to help that individual. And his own confession also indicates that by the time he's sort of shown up and is standing over the situation, then people are already running away. So I think that the 2014 presentation is not quite so clear-cut that it's very hard to draw that inference that they're acting in concert to cause that level of harm to Darrell. Whereas by 2016, now the prosecutor has washed away any equivocation. Like when it comes time and a grand juror says, well, were they holding him down when the gun is shot? Then she says, now's the time to tell us. Tell us if that's not correct. And he says, yes, they were holding him down.
So
She
even
doesn't
if
correct
they,
that.
let's just say they weren't, you're saying they ran away.
That's right, Your Honor. And I think that his
They
plea
ran away after
allocution-
he was shot.
No, they were already beginning to disperse and disengage before he was shot, is what I'm saying.
So, but didn't they clear a path, so to speak, for this to happen? They beat him up because he was going to intervene into his cousin, right?
I think that
That's why they beat him up. They beat him up to stop that and to prevent him from being able to do anything.
And that's the serious
from
thing.
running, from defending himself, from anything else. That is what they achieved, so that he could come and then do whatever he wanted, shoot, whatever else, without them intervening.
It's that final link that I think is missing, Your Honor. It's not so that he can then show up and do whatever he wants. It's that they're just engaged in fighting him off because everyone's in a fight. And so I think that the grand jury, because it didn't have that information in front of them, we can't trust the calculus that they made. That's why these proceedings, I have not found a case where this level of misleading testimony went uncorrected for so long. And so this is why it rises to a Pelchat-Huston level of a grand jury impairment. And then again, that's why what Mr. Arias is asking for here is a conviction that lines up more closely with what he actually did and lines up more closely with what he allocated to. I mean, he allocated to being engaged in this brawl, being engaged in this fight. He was not aware, he heard a shot, he wasn't sure where the shot had landed or what had happened because he wasn't there in the mix of it holding someone down. And so that's why he's asking for this court to convert this conviction
Counsel,
to...
wouldn't your remedy anyway, even if you were successful in your argument, wouldn't your remedy be a new trial rather than a reduction? Is that a legal sentence to just reduce?
It is legal to convert it to a lesser included, Your Honor. And there are 3 cases that we cite in the reply brief. Meyer, Hutchins, and Reyes from 3 different departments, including this one, where after a plea, reducing to a lesser included is appropriate, especially when we're dealing with issues of fairness like this. And I think it's particularly important that the prosecution relied on this testimony in that motion to reinstate, and the prosecution sanitized that testimony at the second grand jury. No one was ever informed about it. I'll reserve the rest for rebuttal.
Good afternoon, Your Honors. May it please the court. Connor Burns for the people. Just to begin, even before we get to the merits, defendant's claim here is foreclosed by his valid guilty plea. It's not his claim, his attack on the indictment on appeal here is purely evidentiary, and it's not of a constitutional nature that would survive his plea. I know in their papers they rely on People versus Pelchat to argue that the exception here would apply here, but the case is readily distinguishable. In Pelchat, the grand jury proceedings were found to be defective because the only evidence of the defendant's guilt in that case was just unquestionably false testimony of his involvement in a drug operation. He was never involved in the operation, and then the detective falsely testified before the grand jury, and the prosecutor was made aware of this, didn't disclose it to the court, and allowed the defendant to plead guilty. But here, just unlike Pelchat, that there was ample evidence of the defendant's guilt that's uncontroverted or uncontested on appeal. As Your Honors have been discussing, the uncontested evidence is that the defendant and others attacked the victim. They punched and kicked him until he fell to the ground, and then while on the ground, they continued the attack, and they held him down as co-defendant Harris came over with the gun and pistol whipped him, hit him multiple times. And that's the uncontested evidence of the defendant's involvement in this crime. So the only evidence that they do take issue with on appeal to the counsel is the fact whether or not the defendant was holding the victim down at the time he was shot. And that's why...
Or whether they were running away and dispersing at the time he shot. After they pistol whipped, after he was hit with the gun, whether or not they started to disperse at that point.
Sure. So I would like to correct that. I know counsel did bring that up. I think Levon's testimony, and he was the only witness to the crime, Levon's testimony was that, the uncontested testimony is that at the time, the group had held the victim down as he was being hit with the firearm. They then stood up and let him go, and then as the shot was fired, after it was fired, that's when the crowd dispersed. So it was at the time of after the shot was fired that the crowd fled. So I think, because, again, there is uncontested testimony and the evidence that, again, is uncontroverted is not false, and it's not a situation like Pelchat, so defendant's guilty plea would foreclose review of his claim. And I think it's also
Okay,
worth
I understand that the guilty plea may foreclose this, but what about the facts as they are? The difference between what was presented in the grand jury and whether or not that there is an issue there?
Sure. Well, I think the difference in the inconsistency in the testimony is we would argue inconsequential. It wouldn't the first degree manslaughter charge wouldn't rely on the fact that the defendant was holding the victim down at the time he was shot. The consistent and the uncontested evidence is certainly sufficient to support the first degree manslaughter charge. And again, it would provide the grand juries with the least reasonable cause, and that's what we're dealing with here at the grand jury stage, reasonable cause to believe that the victim, that the defendant intended to cause serious physical injury and helped and aided the co-defendant Harris in bringing about the victim's death. And I think that's certainly the case, even though the defendant wasn't armed and didn't inflict the fatal injury, as counsel argues. There's certainly ample evidence of his involvement in the crime that would lead the grand jury to believe that he was guilty, or it was reasonable cause to believe about the manslaughter charge. And now just turning to the final point, that the prosecutor did not abdicate her duties here, did not engage in prosecutorial misconduct by not eliciting this inconsistency before the 2016 grand jury. Again, there was ample evidence of the defendant's guilt, and this duty isn't triggered when there is no reason to believe that an indictment is based solely upon false evidence. And again, that's certainly not the case here, because there's a myriad of uncontested evidence of the defendant's guilt. And Justice Caro, down below, when he reinstated the manslaughter charge, didn't rely at all on the facts or on the inconsistent testimony. His main reasoning for reinstating the charge was the fact that the defendants, again, held the victim down as he was being pistol whipped, and that cleared a path for Harris to shoot and kill him. It was the fact that they immobilized him and got him to the ground and made it much easier for him to shoot and kill him. So that was the critical fact and the reason that he felt, Justice Caro, that the manslaughter charge did have sufficient evidence to support it. If there are no further questions, we ask that that this case be affirmed.
Thank you.
Thank you.
Counsel, is your adversary correct that Levon testified initially that defendant aided in restraining Darrell, knocked him to the ground, which essentially permitted Harris then to do the shooting? Isn't that what?
I think the crux of the testimony, Your Honor, is that they were kicking and punching and holding him up as he's getting hit by the gun.
But knocking to the ground as well?
It's like they're bringing him down, they're holding him up, they're kicking and fighting. That's the point. It's very difficult to understand.
So based on that, isn't defendant complicit in the killing? And
I think
weren't
that
they
I
acting
only,
for
I'm
a
sorry.
common purpose? They were complicit in the killing, and weren't they acting for a common purpose here?
I don't think we can draw that inference from that evidence that he was in part of the actual killing. I think we can draw the inference, and the grand jury could draw the inference, that he was taking part in the street brawl and that Wayne Harris was coming in and escalating that conflict. But it's only the act of them really holding him down at the moment of shooting, the false evidence or the completely changed testimony, that really would lock that in. And that's why I think in Huston, if I could just quickly sum up, in Huston, the Court of Appeals said that even if there might be some legally sufficient way to get there, when the grand jury is impaired like this, then that count is not proper and we should not
They
trust
beat
it.
him so badly that he wasn't able to get up. I mean, they were beating him, he was on the ground, or to the point where he wasn't standing on his own. And it's at that point that the other individual came and hit him with the gun and then shot him. There's the one that happened first, where once the other individual came over and hit him, they stood up. That was the first one. In the second one, they continued to hold him. Those are the two differences. He's unable to move, to get up, to do anything in either case, whether they were holding him or they stood up at the time he was shot.
Well, and the co-defendants who went to trial, Your Honor, were acquitted.
I didn't hear you, sorry?
The co-defendants who went to trial, Your Honor, were acquitted. So I think when the whole story was heard, then those inferences came out differently. Thank you.
Thank you both.
I know, it's a stretch.
It's in this belt. It kills me.
I know. Somebody wrote on the loose